Hello and welcome to another installment of our show, The Docket. As many of you know, and for those of you who don't, The Docket deals with legal issues and entities that affect you and our community. We try to present these things in both an understandable and enjoyable way. Thanks for joining us, and certainly we welcome any feedback or suggestions you might have. We'll be right back with today's guest, so please stay tuned. This is the second part of our discussion about the death penalty, and I want to welcome back both Edythe Payan and Bridget Sakells to continue the conversation. Edythe is one of the limited numbers of attorneys in the state who are qualified to defend a death penalty case, and Bridget is what is known as a mitigator. A mitigator is required to be on the defense team of every death penalty case. So just to remind those of you who saw the first part of this show, and those of you who are now joining us for the first time, I'm going to ask Edythe to explain just what types of crimes qualify for a death penalty case. So would you take over, Edythe?
Yes, so under the Texas Penal Code, there is a limited number of crimes in which the state of Texas can choose to give notice to seek the death penalty. And it starts with a murder would be your capital murder. So first you have to have a murder intentionally, knowingly causing the death of someone, and then there are aggravating factors. So it's intentionally, knowingly causing the death, plus intentionally, knowingly causing the death of two people, where you intend the death of both persons, neither person which you would have caused their death accidentally, intentionally, knowingly causing the death of someone that you know is law enforcement, a child under 6 while in the course of a robbery. So you're intending to rob a convenience store and you intend to kill the clerk. Those are probably your most common basic examples.
And you keep using the word intentionally, so I guess that's very important in determining whether it's a death penalty case.
Correct. There are different what we call culpable mental states, in which someone could cause the death in someone. Obviously, a car accident, that wouldn't be intentional, or if you're behaving recklessly and you, in some other manner, accidentally kill someone. So this is, I want you dead. I don't want to hurt you, and you ended up dying. It's very clear. I want this person to die by whatever manner, plus the aggravating factor.
All right. So, and those are the types of cases that qualify for the death penalty punishment.
Yes.
But Texas has a bifurcated trial system, correct?
Yes.
And what that means is that you have a guilt or innocent stage, and then if they're found guilty, you have a punishment stage. Obviously, if they're found innocent, you don't move on to the punishment stage.
Correct.
So, Bridget, you as the mitigator, when the case is given to your office, and I'm just going to say you and Edythe start working on it, your job is to do what?
So my job at the beginning is to start building a life history of the client and go back and do a full investigation from prenatal all the way up to current day.
And that sounds pretty exhaustive.
It is.
Okay. So, but what are you looking for?
Anything that can help us explain how this happened.
So give us some examples of that, if you could.
It starts with the prenatal investigation to see if the mother was under the influence of any drugs or alcohol during her pregnancy.
Which might cause a brain deficiency of some sort.
Correct. And then we'll go through all the school records to see the history of the person as far as their ability to learn, any type of intellectual disability that may be there. And then we move on to mental health screening and any past history of things like that. And we do a full life investigation into any history of abuse, trauma, any type of events that have transpired in the person's life that could have led them to be in the situation that they're in.
And so, and one of the reasons, and I want everybody listening to really think about this, one of the reasons that has to be exhaustive, I think, is because you're trying to save somebody's life.
Correct.
He's already been, or she's already been convicted of killing someone and meeting the requirements that Edythe just went through of a death penalty case. But the pressure on you guys is that your job is to try and get this person life without parole rather than the death penalty. Is that right?
Yes.
At that point. I mean, he's
yes.
already been convicted.
Correct.
So now, you know, he's either going to get the death penalty or life without parole. Is
That's
that correct?
Yes.
Do you go back? I mean, I think, do you travel to do this? And how intricate is this?
We do travel. So on a death penalty case, you'll go to where the person grew up generally and meet people that knew them as a child, knew them as an adolescent, as a young adult. You try to find people that have knowledge of their history that can help us explain, you know, where the person
What may have caused this person to act the way they acted?
True. And where they actually may have had trauma in their life.
Right.
Mm-hmm.
And do you look for people, and again, I don't know this, when I was practicing as a lawyer, I never did this type of work, but I mean, do you look for people who perhaps would testify to his good character? And I think we had spoken before we started doing this taping, and you used a phrase and you said to me, the worst thing a person doesn't necessarily define their life. And that's what you're looking for, right? The better, either the reasons they may act the way they act, well, basically the reasons. Is that right?
That's part of it. And the other part is, you know, humanizing them and showing where they came from. We don't know that until we go there and actually look at it ourselves and see the house that these people grew up in, the house, how many times they moved. We'll just, you know, we've had clients who have lived in 40 different places in a period of, you know, less than 10 years. It's that kind of upheaval in the life, especially as a young child, trying to make friends, but they're constantly moving, things like that.
I'll ask you about another example because it has to do with a book I'm reading. But would you look, let's say, for a mother who would testify, yes, my husband beat my son continually and I should have stepped in, I should have done something, I didn't. Do you look for things like that?
That happens. That does happen. We also talk a lot to teachers, coaches, members of, you know, religious organizations that might have had involvement in the person's life in the past. We reach out to neighbors.
Do you ever get any reticence from these people talking to you because they feel that maybe they should have stepped in back when some of these things were happening?
It's rare that I've found people that aren't willing to talk to us, and I don't know all the reasons, but that definitely could be part of it, yes.
For them not wanting to talk
right.
to you. Yeah. But you don't run into that much. Most people are pretty open?
Most people are. Most people want, well, I think they have morbid curiosity too. They want to know a little bit more about what happened, so they want to talk to us.
I think you forgot the word morbid before curiosity. But So let me ask, you're doing this, and while this is going on, let me back up for 1 minute. How long is the process, from when you get assigned, and this is for either of you to answer, when you get assigned a death penalty case till you get to trial? How long is that process generally?
Before COVID, typically it would take 2 to 3 years.
Really?
Yes.
And during this time, I'm assuming the person's not out on bond or?
No.
Okay. During this time, the person's in jail and you are doing all of this work. I mean, that's how exhaustive it is to try and save this person's life.
And yes, they will be in jail because we would have had a bond hearing, and the bond would have just been set so high due to the nature and circumstances of the offense, danger to the community, but we will litigate, we will try to advocate for a bond hearing, but yes. So they will remain in jail. The client is in jail the entire time. And it's we work as a trial team, so obviously we have Bridget, we have investigators. We'll usually have 2 or 3 on a case like this, a first chair, a second chair, a third chair, secretary, staff. So it really takes a team. And then there's also the involvement of your client as well. They'll give us some information. Bridget will get some information. You'll go follow up, or they'll say, oh yeah, I just remembered. When I used to live here, there was this other neighbor. So it's a very exhaustive, collaborative process.
What's the difference between an investigator and what Bridget does as a mitigator?
It's hard to delineate exactly. I mean, typically you could say an investigator is out there looking for people. Maybe they've gone to the crime scene to take pictures, talking to witnesses about what happened that day, eyewitnesses, if there are any. They're not looking into all the factors that Bridget, as a mitigation specialist, will be doing.
Okay.
She also has a degree in social work. So
I was going to ask,
right.
yeah.
But there are times they have to work together. Like if there's a witness or a teacher Bridget needs to find, she will work with the investigator to find the teacher.
Oh, I see. Okay. Like hiring a private investigator to find somebody.
Exactly.
All right. So then there's a team, there's a defense team. How, over this 2 to 3 year period, how often do you get together?
Depending on schedules, in the beginning, I mean, every week, every day, there will be a formal trial team meeting,
Right.
or there'll be phone calls or text or going in and out of people's offices. As you get closer to trial, you'll start meeting more
frequently.
I mean, at least, once a week, several times a month.
All right. So now, as Bridget's doing this, she's feeding you this information periodically, right? Oh, listen to what I found out, or I just went someplace and I spoke to this woman, and she's feeding it to you. You're sort of aggregating it, I assume, so that when you have to appear in front of the jury, you know how to integrate all of this information into your arguments to basically plead for the guy's life. Is that right?
Yes. I mean, we would have chosen who the witnesses will be. Obviously, the judges, you need witnesses. If Bridget found 20 witnesses, we may or may not want to call all 20
Right.
witnesses. Some will be stronger than others. So ultimately, we have to make those decisions as a trial team. Who will be the best witnesses to present the evidence or the testimony for the jury?
So now, obviously, the jury is the final arbiter of what's
Yes.
going to happen. So would you take us through the whole process of how the jury for a death penalty capital murder case is chosen?
Okay. So there's similarities to a regular jury for those who've had to go to jury duty. The first step is you get in the mail your jury sheet questionnaire. It's a 1-page questionnaire, basic information, name, profession, your parents' profession, if you've ever been the victim of a crime. It's very basic. And that information you fill out and you send back to the district clerk, or you can do that online now. And then just like with any other type of case, on a certain day, you're called to go downtown for jury duty. So what would have happened in a death penalty case is 200 people would have been summoned to go down for jury duty. And in addition to that questionnaire they've already filled out, they will be presented with a very exhaustive 10, 15-page jury questionnaire that the defense and the state and the court would have worked on.
And this is after they've been called down, so you give this to like the 200 people sitting there.
So yes, let me back. So the 200 people sitting there, the judge would have gone through their qualifications or exemptions. Some people may have an exemption for childcare or whatever the case may be. So some people might be excused. But of the ones that are left, they get the questionnaire, they will fill it out, they will turn it into the bailiff, and then the defense and the state will get copies of that questionnaire. They're usually given about 2 or 3 months to review it, and then the process of voir dire begins, and it's very different from a regular case.
Let's stick with the questionnaire first, then
Okay.
we'll go into the voir dire. I'm going to use the word intrusive. I don't know if you view it that way. Maybe you view it as informative, but I have seen it had 400 questions. It was the one I saw. And when I say intrusive, I don't really mean it in a bad way, except I can see a lot of people being very aggravated having to fill this out. And that's the last thing I think that you would want. You don't want people coming on the jury who are already ticked off.
And we try to explain, yes, this may seem intrusive, but we're not asking these questions to be nosy. We're not asking these questions just because we can. There's a reason. It's, to ascertain their bias, their opinions, how they feel about certain views. And sometimes, depending on the answers to the questionnaire, they may not get called on it just depends.
And you think we had talked about this too. Some people so don't want to serve that they'll put stuff on the questionnaire that would pretty much automatically disqualify them, right?
Well, yes, and there are people that have legitimate reasons that
Sure.
might disqualify them.
Yeah, both sides,
Yes.
but and then they get disqualified. How many do you need before you start the voir dire?
That's hard. Usually you want a pool of about 200 because you're going to be asking them a lot of questions. A lot of jurors will be excused perhaps for cause by the judge, and then you need your pool. So you want about 200 back to start off with.
All right. And so now talk about, if you would, the actual type of voir dire you do in a death penalty case.
So
let's explain what a voir dire is first.
Voir
Yeah.
dire is to see, to speak, and in a typical trial, the 100, 200 people are sitting there in the courtroom and both parties ask questions. In a death penalty case, you're called upon individually, and the state asks questions and then the defense asks questions. The judge is there, the defendant, the client is there, and so the questions are going to be different. Obviously, they're going to lean specifically towards the death penalty. They're going to lean towards some of the issues that we've been talking about with Bridget. Like, there may be some issues that may be too difficult for a juror to have to sit and listen to. If there was some sexual abuse in the defendant's life and a juror may have been a victim themselves or had a close family member, they may ability to affect their ability to be fair. So you have the opportunity to ask them more personal questions, and again, specific questions about the death penalty and their views.
And also, you're delving into that form that they've already filled out.
Right. There may be something specific that we may want to follow up on, or for clarification.
Okay. And do you go through the entire 200?
It depends. Sometimes there may be other reasons to excuse someone. It just depends on what happens. But yes, sometimes we had a case once where we had to do it again and bring in a whole other group.
Because there weren't enough
enough.
out of the 200.
Yes.
And then the jury is ultimately made up of 12 individuals with 2 alternates. Is that?
Yes, and the court would decide the alternates, but you're going to have at least 2. Yes, you have 2.
Just explain for a minute. I mean, it may be self-explanatory, but why do you have alternates?
Well, you will typically have an alternate, at least one anyway, on just your run-of-the-mill murder case, but on a death penalty case, you will need those alternates because the case takes that much longer. You could have a week, 2, 3 weeks of testimony. You need an alternate in case a juror gets sick, in case there's some kind of emergency. The alternates sit and listen to everything as one of the first 12.
And I think, so a lot of people, excuse me, don't want to serve on a jury because they have a job. And they're not going to get fired from their job, but they don't have to be paid for the time that they're away from it. Isn't that the law?
Yes, an employer does not have, and especially people that have their own business, you do get a check from the county for every day you serve. I think it's up to $40 now, but yes, it is a burden, but clearly I believe it's a duty. It's one of our duties as a citizen, just
no
like
question.
right, just
Yeah.
like you have your right to a trial, you have your duty to participate.
It's a difficult duty
It is.
to perform
Yes.
for many people, and I think most people take it very seriously and listen to what the attorneys are saying. And the burden for a jury to decide whether you're going to put somebody to death or give them life without parole is a huge. I mean, I don't know that I'd want it. And we've talked to the stress on you guys must be incredible what you have to carry. I mean, you've been working on it for 2 or 3 years, and now, push comes to shove, and you're at trial, and I can't imagine.
Well, that's where you have a good team. You rely on each other. You try to have a work-life balance, but probably those 3 months of this jury trial, there's no life. It's just all work.
I bet. So now let's talk. And you said the trial could go 2 to 3 weeks.
The actual evidence.
Yeah.
Once you start with the fun part.
Right.
But picking the jury could take 2 to 3 months before you even have your jury to start the evidence.
Because you're doing it individually,
Yes, sir.
200 people, so on and so forth.
4 or 5 a day, typically maybe 3 or 4 days out of the week, because everyone needs that one day. The court needs a day to handle the court's docket.
Right.
The parties need a day to do other work.
You have other stuff to do. Are they sequestered?
Not during the individual voir dire process. They can be sequestered during the evidentiary. That's up to the attorneys, and they can be sequestered during deliberation. That just depends.
Do the attorneys both have to agree if you're going to sequester a jury?
No, one side.
And if one side asks for it, the judge automatically grants it?
Yes, and
So-
the jury doesn't know who.
Oh,
So that way the
okay.
jury doesn't
Yeah.
know who to be mad at. Yes.
All right. So now it's we're done with the guilt innocent stage. How long is there between the guilt innocent stage and the punishment stage, or is it a continuum?
It's a continuum depending on witnesses. So sometimes it's hard to time, right? If you've had 2-3 weeks of evidence and you're going to have this punishment phase. You might have, like Bridget said, family members that we found in Phoenix or Arizona. So you might maybe get a week in between or a few days just to handle scheduling matters. But it's not like in the federal system where, sentencing is a month later.
Right.
It's back to back. It's just up to the court and the parties.
You just brought up something that I had not thought of, and we hadn't talked about it. The witnesses in the guilt innocence stage are different or can be different than the witnesses in the punishment stage.
It can be, yes.
Okay. Because primarily, again, and I keep saying this, what you're doing is trying to save somebody's life. That's your job. So you are now Bridget has done all this work over this 2 or 3 year period of gathering the information about the fellow's background and talking to people that he or she knew and so on. What are some of the arguments then that you can make based on what, and you've made them to me. I mean, I was a hardcore, you really educated, both of you educated me in this. I was one of those people, he was guilty, death penalty. And I honestly am not anymore based on what you guys have taught me. And so it just kind of, if I were on a jury, what would you be saying to me to try to convince me that, no, the death penalty is not appropriate?
Right. So again, like you said, clearly this person is guilty. So none of these arguments are what we would say, it's not an excuse, but it's something in some way that might mitigate or lessen their personal moral culpability, something in their background. Again, I know I keep going back to this example, but if they had been sexually abused, maybe there was something in the actual offense that may have triggered something in his past, or if there was maybe something that was going on with their mental health issues, if they were dealing with a bad divorce or depression or separation, something would have triggered it so that there's this culmination. There's just a lot, or maybe you might have someone that would say, this guy was a great kid, he was good, he was a great student, he was kind to, to his friends, and here we are, just so that the jury knows more about this person, as Bridget said, to humanize them, to say this is not someone we want to kill as the state of Texas.
Again, it kind of goes back to what I had said. I don't know if I'm quoting you correctly, but the person's worst act does not necessarily define that person. So, I mean, again, I get not emotional about it, but I'm so torn about all this stuff, especially, the way you're explaining it and why some of these things could have happened. And I certainly am not that hardcore, he's guilty, kill him sort of guy. But the jury has to, and you're voir dire. And is it only in Texas that we say voir dire, or do they say voir dire in other?
I believe they say voir dire in other, in other jurisdictions, not in Texas, right? We say voir dire.
So, you can, I mean, I think I learned about it with everything you gave me to read, that mitigation has to be considered. Yeah. You have to be able to present the evidence of mitigation, and the jury, by law, has to take mitigation into effect when they're making their decision. It doesn't mean they have to say life without parole. But when they make their decision, whether it's death penalty or life without parole, they have got to have considered the mitigating factors. And if for some reason it comes out that they didn't, the whole thing can be appealed and sent back to the trial court again. Is that right?
Arguably, but going back to what you're saying, that's why this process is so important. And that would be a question. The question would be, assuming hypothetically that you, Bob, as a juror, have now found this person guilty of intentionally, knowingly killing a child, can you now keep an open mind to mitigation, to different types of mitigation? I can't get you to agree, if I give you evidence of this, will you spare this person's life? But you have to say, yes, I can keep an open mind. If you say something like, well, I can keep an open mind to guilt innocence, but if I find this person guilty of this offense, it's death penalty for sure. In that case, you can't be a fair juror.
I can't believe how quickly this has gone. I want to thank Edythe Payan and Bridget Sakells again for being our guests I'm sure this isn't the last time we're going to hear from them. Please join us again, and you can see all of our episodes of The Docket on EPCC-TV on YouTube. So thank you, and see you next time.